Welcome back to Organize, the business law breakdown. In this episode, we're delving into one of the most fundamental aspects of contract law. How do courts decide when someone lives up to their end of a contract? When is a party allowed to withhold their performance or even cancel a deal and sue because the other party didn't fully or partially deliver on promises? So today we'll explore the difference between complete performance and substantial performance, using real-world cases and a few fascinating hypotheticals. We'll also cover the major doctrines that allow one party to withhold performance and cancel performance where others fail to perform as agreed. So by the end of this episode, you'll have a much deeper understanding of how performance impacts contracts and how courts determine when a breach is material or total. But before we get into the specifics, let me tell you the 3 key takeaways you'll learn from listening to today's episode. These are important to keep in mind as we're going to navigate some complex performance, breach, and condition issues. First, we'll parse substantial performance and material breach. You'll learn how courts evaluate whether a party has substantially performed their obligations or materially breached the contract. Second, we'll distinguish material breach, which is curable, from total breach, which is irredeemable. And we'll distinguish how to determine when parties can walk away from a contract and when they have to wait for the other party to cure. And we'll learn that for each form of breach, no matter how minor, there can be damages, because parties are always entitled to seek the expected benefits of a bargain. By the end of this episode, you'll have a solid understanding of how courts decide when performance has been enough to meet contractual obligations versus when a party has fallen short. So stick with me as we tackle this essential topic. Let's dive into some key principles that will help you understand how courts evaluate performance and breach in contracts. First, we have complete performance. And complete performance is pretty straightforward. It's when a party fully performs their obligations under a contract, and so they're off the hook. They've done what was promised and the contract is discharged. They have no further obligations. But that doesn't mean that every minor failure to completely perform is a total failure. Sometimes things don't go exactly according to plan, but the job is still done well enough, which brings us to substantial performance. Substantial performance is when a party fulfills most of the contract and falls short only on minor details. In technical language, we could talk about the material purpose of the contract being effectuated. Courts will still enforce the contract, although the breaching party might owe some amount of damages, expectation damages in particular, for the incomplete portion of their performance. On the other hand, a material breach occurs where a party fails to fulfill a crucial part of the contract, and when it undermines the contract's essential or material purpose. If a breach is material, if it undermines the fundamental purpose of the contract, then the non-breaching party can withhold its own performance. The non-breaching party can refuse to perform its own mutual obligation as a sort of leverage to incentivize the materially breaching party to cure and thus at least substantially perform. So the difference between substantial performance and material breach regards whether the non-breaching party has to perform mutual obligations. If the breach is immaterial, the performance is substantial and mutual obligations are due. If the breach is material, the performance is unsubstantial and mutual obligations can be withheld for a reasonable time to allow the breaching party to cure. And how long is that time? While a material breach is one that's substantial and where there's still hope for repair, a so-called total breach occurs when that hope is lost, and it's no longer necessary to wait for performance. Courts determine whether a breach is total or material based on many factors, including the degree of the breach, the harm from further delay, and the expectation of timely performance by the parties. As a reminder from last week's episode on conditions, remember that the concept of implied mutuality of obligation exists in most contracts. In many contracts, the obligations of one party are contingent on the other party's performance. So if one party doesn't perform, the other party is typically justified in withholding their own performance, because these performances are typically understood to be mutually conditional on one another. They are implicitly mutually conditional. This mutual dependence is crucial for understanding how contracts work. Now let's break it down with the landmark case of Jacob and Youngs v. Kent, which highlights the distinction between substantial performance and material breach. Here's the setup. Jacob and Youngs was hired to build a house for Mr. Kent, a mansion in fact, and the contract specified the use of a particular brand of pipe, Reading pipe to be exact. When the house was completed, Kent discovered that a different brand of pipe had been used in some parts of the construction. Though the court found that the alternative pipe was of effectively equal quality and certainly served the same purpose of getting water to the toilets. The legal question was whether this deviation amounted to a material breach, which would allow Kent to withhold payment, or whether it was a case of substantial performance, meaning the contractor had fulfilled the main purpose of the contract and deserved to be paid. The majority of the court, led by Justice Cardozo, ruled this was a case of substantial performance. The contractor had completed the house, and the use of a different brand of pipe didn't undermine the essential value or function of the project overall. As I mentioned, the water still ran in the sinks and the toilet still flushed. According to the court, the law doesn't require perfect performance, only that the core purposes of the contract should be met. Kent was still obligated to pay the contractor. He could seek a reduction in price to account for the difference in pipe brands, but Cardozo determined that the pipe was equivalent in value, so Kent basically had to pay full price. However, Judge McLaughlin dissented. He argued that strict adherence to the contract's terms was necessary because there were express conditions in the contract. In his view, if the contract reading specified Reading pipe, then using anything else, even if it was functionally equivalent, constituted a breach, because the use of the term Reading pipe constituted a condition for payment, an express condition, not an implied one. The dissent raised an important question about contract enforcement. Should courts prioritize flexibility and fairness in interpreting contracts, as Cardozo seemed to, or should they hold parties to the exact terms that they agreed to, as McLaughlin did? For McLaughlin, even a small deviation justified withholding payment because this was an express condition. Moreover, for McLaughlin, the court overstepped by determining that Reading pipe is no better or worse than generic pipe. How could the court know the quality of pipe without taking scientific testimony on the long-term benefits and detriments of different brands of lap-welded, galvanized pipe? The tension between the majority and the dissent reflects a fundamental debate in contract law. How far can parties deviate from the exact terms of a contract before it becomes a material breach? While the majority favored a more practical approach, ensuring that contracts don't fall apart over minor issues, the dissent emphasized the importance of certainty and predictability in contract enforcement. The ruling in Jacob and Youngs v. Kent showed that courts will sometimes excuse minor deviations if the main purpose of the contract has been fulfilled. But the dissent reminds us that strict compliance with contract terms is equally important in maintaining the integrity of agreements. Let's explore a what-if scenario to better understand the line between substantial performance and material breach. What if you hired a contractor to build a kitchen in your home, specifying a particular brand of countertops, let's say Granite X brand? The contractor completes the kitchen, but when you inspect it, you find a sticker underneath that says the brand of granite is Granite Y, not Granite X. The countertops look good, and Granite Y is apparently of the same quality and durability as Granite X, but it's not what you ordered. Do you have to pay? In this situation, courts would likely apply the doctrine of substantial performance, just as they did in Jacob and Youngs v. Kent. The contractor fulfilled the main purpose of the contract, building your kitchen with high-quality granite countertops. The brand swap is probably a minor deviation, not a material breach, so you'd still owe the contractor payment for the work. But you could seek a price reduction if Granite Y is less expensive or doesn't meet the exact specifications of the contract. But what if the countertops are made of a cheaper, less durable material that doesn't meet the contract standards for quality? What if you could show that Granite X has larger crystalline structure that make it more attractive, more resistant to chipping, more heat resistant, and easier to keep clean and sanitized? Now we're talking about a potential material breach. The quality of the countertops directly affects the functionality and value of the kitchen, which might justify withholding payment until the builder replaces your countertops, or if the builder refuses, might justify even terminating the contract altogether. So let's take it another step. What if the contractor installed the wrong countertops but offered to replace them with the correct brand at no additional cost? Well, now we're in the territory of curable breaches. If the contractor is willing and able to fix the problem without delaying the project significantly, you are probably required to allow them to remedy the breach before you can choose to withhold payment. A curable breach is one where the non-breaching party can still receive the primary benefit of the contract, but the performance is substantiated yet. The breaching party has some opportunity to correct the issue, and the non-breaching party may be required to allow them to do so. This is where the law emphasizes fairness and the chance to remedy mistakes. Let's revisit our earlier kitchen example one more time. Imagine the contractor installs the wrong countertops, granite Y instead of granite X, but immediately offers to replace them with granite X as specified in the contract. Again, to be clear, since the issue is fixable and will be fixed without significantly delaying the project, this is what we call a curable breach. The contractor is allowed to correct the mistake, and the homeowner must give them a chance to do so before the homeowner can walk away from the deal. But what if the breach is so severe that it can't be fixed? What if, for example, the frustrated contractor walks off the job saying, "There's no pleasing some people," with no intention to swap the counters? Now it looks like a potential total breach, or an irredeemable breach could come into play. A total breach is a failure so fundamental, it defeats the entire purpose of the contract, leaving the non-breaching party with no real benefit. A court would then ask whether the granite Y countertops meet the substantive expectations. If it's good enough, then you'd have to pay the contractor for his work, and you could sue for the difference in value between granite X and granite Y. But if the countertops simply do not work for your application, for example, if the contractor installed quartz instead of granite, and quartz simply can't handle the heat of your cooking operations, now courts would probably declare you're deprived of the benefit of the bargain and allow you to cancel the contract and find another contractor to install granite X for you. Let's end on an easy case. Let's say the contractor didn't just install the wrong countertops. They also failed to properly install the kitchen's plumbing and electrical system, leaving the kitchen unusable. Now we're looking at a total breach. The entire purpose of the contract, building a functional kitchen, has been completely undermined. In this case, the homeowner can terminate the contract immediately and seek damages without giving the contractor a chance to fix the issue. The flagrancy of that breach tends to show grounds for termination of the contract. Curable breaches offer an opportunity for resolution, but total breaches leave the non-breaching party with the right to walk away and demand immediate compensation. This distinction is crucial for deciding whether a party should continue working toward the contract's completion or whether they're entitled to stop and pursue legal remedies. Let's break it down with another case. In Kitterer v. Bell, Dr. Bell, a dentist, agreed to replace 3 of Ms. Kitterer's teeth with crowns. Kitterer claimed that she expected porcelain fused to metal, or PFM, crowns, and Bell had written PFM in her medical notes. But Bell used all porcelain crowns and said her PFM notation was just her generic way of saying crowns. Dr. Bell refused to replace the PFM crowns with all porcelain ones, saying it was medically unethical to remove perfectly good crowns. And Ms. Kitterer, for her part, refused to pay. Kitterer argued that all porcelain crowns were inferior in durability to PFM crowns, and claimed, moreover, that she didn't get what she wanted, so Dr. Bell breached the agreement. Bell countered that all porcelain crowns were superior in quality and more aesthetically pleasing. The dispute ultimately hinged on whether Dr. Bell's substitution amounted to substantial performance. The court looked to the doctrine of substantial performance, which allows a breaching party to recover payment if they have provided most of the promised performance, even if there are minor deviations. The principle was famously articulated in Jacobs and Young v. Kent, where a contractor used co-host pipe and other generic brands instead of Reading pipe, as specified in the contract. Justice Cardozo ruled that the substitution of pipe, while a technical breach, did not justify the homeowner in withholding full payment because the pipes were of comparable quality and utility. The court in Kitterer v. Bell applied similar reasoning, guided by 5 factors, which you can find in the Restatement Second of Contract, Section 241, to determine whether breach is material or insubstantial. First, the benefit received. Did the party receive most of the value promised of the contract? Second, feasibility of compensation. Could any deviation be rectified through monetary compensation? Third, forfeiture suffered. Would denying enforcement cause the breaching party an unfair loss? Fourth, likelihood of cure. Is the breaching party likely to fix the problem? And five, good faith. Was the breach made in good faith, without deceit or negligence? In Kitterer v. Bell, the court analyzed those factors. First, the benefit to Ms. Kitterer. Expert testimony supported Dr. Bell's assertion that the all-porcelain crowns were high quality, and perhaps even superior to the PFM crowns, so that, in terms of function, Ms. Kitterer got the teeth she wanted. Compensation feasibility. If Ms. Kitterer believed that PFM crowns were more suitable, Dr. Bell could have compensated her for the price difference or replaced the crowns. But it turned out that PFM crowns were actually cheaper than all porcelain crowns, so there was no thing to compensate. Forfeiture. Denying payment for the procedure in its entirety would have been disproportionate, as Dr. Bell would have gotten nothing for work that had provided Kitterer with functional teeth. Curing likelihood. Replacing the crown would have required additional dental work, potentially harming Ms. Kitterer's tooth structure. And Dr. Bell was not acting wrongly in refusing to do something she felt was medically inappropriate, which leads us to good faith. Dr. Bell acted in good faith. She believed that the intention was all porcelain crowns and believed that the all porcelain crowns better served Kitterer's needs. The court ruled that Dr. Bell substantially performed. It found the deviation immaterial and that Ms. Kitterer was entitled to a nominal payment and could not withhold payment altogether. So what did we learn from this case? Well, first, express terms are not always absolute. Even when a contract specifies particular materials, courts may permit deviations and effectively transmogrify express terms into implied ones so that courts are not going to cause undue forfeiture. Second, expert opinions matter. In technical disputes, courts often rely on expert testimony to evaluate the impact of a deviation. And third, substantial performance favors equity. The doctrine prevents parties from using minor deviations as an excuse to avoid major contractual obligations. By the way, what if the all porcelain crowns had been demonstrably inferior to porcelain fused metal crowns? What if the porcelain was prone to cracking or early failure, only lasting an average of 5 years instead of 8? The court then would have likely found for material breach, and Bell's refusal to remedy could have made that breach total, allowing Kitterer to refuse payment entirely. However, again, this court believed that the all porcelain crown had equivalent or better quality. The result, therefore, was substantial performance and nominal damages. The case of Kitterer v. Bell reflects the balance courts aim to strike between enforcing contractual precision and recognizing real-world circumstances. Substantial performance acknowledges that minor deviations, especially those made in good faith, should not derail otherwise fair agreements. As in Jacob and Young's v. Kent, the court ultimately seeks to avoid what Justice Cardozo called oppressive retribution for venial faults. Let's head over to pop culture for a moment. Remember that classic episode of Friends where Ross tries to move his new couch into his apartment? He gets help from Rachel and Chandler, and they end up in a hilarious situation where they have to pivot the couch up a stairwell. In the end, the couch gets stuck, and they break it, trying to maneuver it through the walk-up building. Now, think about the situation in the context of performance and breach. Ross bought a couch with the expectation it would fit in his apartment, and he hired people, though not professionals, which could have been his first mistake, to help him move it. What if he had hired professional movers who promised to deliver the couch without damage, but ended up breaking it? Would this be a case of substantial performance or material breach? Well, let's say that the movers got the couch up the stairs but scratched some of the upholstery along the way. This would likely be considered substantial performance. They completed the main task of delivering the couch but didn't do it perfectly. In that case, Ross would still have to pay them, although he might be able to deduct some small amount for damage from the scratches. But what if the couch was completely ruined during the move, leaving it unusable and unsittable? That would be a material breach. In that case, Ross doesn't get the benefit of the contract because the couch no longer serves its purpose for sitting. He'd likely be entitled to withhold payment and even sue for damages like the cost of removing the defective couch. This funny yet relatable situation from Friends highlights how courts evaluate the seriousness of a breach based on whether the main purpose of the contract has been fulfilled. Let's recap what we covered today. First, we explored the difference between substantial performance and material breach, how courts decide whether a party has fulfilled enough of their obligations to avoid a breach, or if the breach is serious enough to justify withholding performance. We then broke down the nuances between curable breaches and total breaches. A curable breach gives the party a chance to fix the problem, while a total breach undermines the entire contract, giving the non-breaching party the right to immediately terminate the agreement. Finally, we tied it all together with a cute pop culture reference from Friends, showing how Ross's couch situation mirrored the challenges courts face in determining when performance is good enough and when it's not. Thank you for tuning in to Mastering Contracts on the Business Law Breakdown. If you found this episode insightful, please share it with your colleagues or classmates. Don't forget to subscribe so you won't miss our next episode, when we'll dive into anticipatory repudiation. We'll find out what happens when a party announces they're not going to perform before their obligation is even due. That's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Oranburg, and I thank you for tuning in and exploring the fascinating world of performance with me today. I hope you found the lesson informative and helpful. And remember, until next time, keep your agreement strong and your argument stronger.